Greetings, everyone. My name is Rachel Sedlak, and I'm an undergraduate student in the GMU Forensic Science program, and I'm honored to introduce today our speakers for today's Working Together panel. First, we have Kayla Wallace, who is the Coroner Liaison for the State of Montana Department of Justice Forensic Science Division. Previously, she worked as a medical legal death investigator in Denver and Boulder, Colorado. She attained board certification with the American Board of Medical Legal Death Investigators in 2018. We have Dr. Rob Kurtzman, who has served as the Montana Chief Medical Examiner between September 2016 and May 2022 and played a significant role initiating the ongoing transformation of death investigation in Montana. He served over 12 coroner offices as the forensic pathologist over the course of 23 years. Dr. Kurtzman received his degree in osteopathic medicine from the University of Des Moines College of Osteopathic Medicine and Surgery. We have Attorney General Kathy Jennings, who was sworn in on January 1st, 2019, and serves as Delaware's 46th Attorney General. Previously, Attorney General Jennings served as the Delaware State Prosecutor as the Chief Deputy Attorney General for the Delaware Department of Justice. In January of 2017, she was appointed Chief Administrative Officer of New Castle County. During that time, she concurrently served as the county's Public Safety Director, overseeing the New Castle County Police Department, paramedics, and 911 communications. Next, we have Special Agent Jenny Cutalo-Patterson, who has been an agent with the FBI since October 2005. She's been a member of the Evidence Response Team since 2008. She has worked investigations in counterintelligence and crimes against children, and she currently supervises field office evidence response teams. Last but most certainly not least, we have Linda Jackson, who is the Director of Virginia Department of Forensic Science. She has been with DFS since the beginning as a controlled substance forensic scientist in 1995 and has served in her current role since 2013. She is very active in the forensic community, having served on a board of the American Society of Crime Laboratory Directors in the Scientific Working Group for Seized Drug Analysis and the National Commission on Forensic Science. She holds a BS in chemistry from Wake Forest University and a MS in chemistry from the University of North Carolina at Charlotte. Please do wait for the mic to come around for questions and enjoy the panel.
Good morning, everybody. So as you can see, our panel is called Working Together. So we brought this panel together in response to some questions that were brought to try to answer, how do you communicate with other agencies that you're working with? We have a very strong panel. We're going to start with Special Agent Patterson. And she's going to talk about her experience and how you come into different regions and different realms and work together in partnership to get through cases.
Okay. Good morning, everyone. I've had the luxury, I guess I should say, of working both as an investigator as well as working in kind of the crime scene CSI role. As you heard in my introduction, I've worked cases for numerous years, as well as working as an ancillary duty, kind of that crime scene role. While I was working cases, a lot of what I did was on a task force. So not only did we engage with other FBI offices in different states, but I also engaged with the state and local partners as well. A lot of our federal investigations, if they're not in the office that we're in, we will reach out to whatever office that it is, and we provide them all the case details. We work with them to build their cases so that they can move forward to be prosecuted. A lot of times, if we're the initiating investigator for that, that would require us to work with the assistant United States attorneys in that division. So we would be having those conversations as well as with the United States attorneys in our own divisions. If we happen to decline a case for the federal prosecution, we would work with the state and local partners in our divisions. And a lot of times that requires us to work with the state and local prosecutors. I would say one of the biggest hurdles, mistakes, I don't know if that's the right word to use, that I see in that realm is the state and local prosecutors not feeling like they have to prep us enough if we're going to trial. They think that they can, have a 30-minute conversation because they're like, oh, you're federal, you're so used to testifying and doing all these things that we don't really need to prep you that much. And I will say, since I know there's a lot of prosecutors in the room, please do not neglect that part of it. We need the prep just as much as everybody else, because we want to make sure that you guys understand all of the evidence that we're bringing you for an investigation, and that we're saying the things that you need us to say, obviously, so that we can get the win on the prosecution part. When I'm working in the evidence response team world, we're kind of on the other end of things, where I'm engaging with the case agents, not so much the prosecutors at that point. I'm engaging the case agents as, we're here at your crime scene to collect the evidence. What is it you need from us? What does the search warrant say? What does the AUSAs want? Are they looking for anything in particular? You're the case agent driving that set of collections for us. If we are on larger crime scenes and there are murder victims, we often send our own team to the medical examiner's office to work with them on getting the evidence, the photos, all of the things that we need to help build that case as well. So from the federal perspective, we kind of deal with, I'd say, just about everyone that we've got on the panel. And it all depends on what role we're taking as part of that investigation.
So Dr. Kurtzman, can you talk to us a little bit, as your role as a medical examiner, how you get information and how you can give information back to both the field and moving into the lab, and how that relates in your ability to bring the two concepts together?
Sure. So as a physician, I didn't start off in the multiple forensic disciplines. As a physician, as a pathologist specifically, you're looking at disease and how it affects the body. And we're looking at the determination of cause and manner of death. More specifically, I'll say cause of death, because manner can sometimes be sort of a gray area. But our role in many ways is mostly epidemiology. What diseases, what problems are prevalent in the community, because we want to use that information to improve the well-being of the public. In terms of forensic pathology, we're certainly determining the cause of death, but we're at sort of an interface when it involves criminal investigations, because there's lots of evidence that has to be collected and preserved that you all are processing. And I know for me, in my role, how should I say, as a fellow learning forensic pathology, one of the things that was really important was spending time at the Northville State Police Crime Laboratory in Michigan, looking at chemistry and firearms and tool marks and latent prints, so that we had a good understanding of what do you guys need, as much as you guys would come and take a look at an autopsy and see what we could offer to that table. So far as death investigation is concerned in the United States, you have medical examiner systems, you've got coroner systems, and you've got combinations thereof. And the most important part is trying to disseminate information between the investigators and the coroners and the forensic pathologists. And then, of course, we'll coordinate with law enforcement or whoever we're getting the information from. And I'd say the most important part is that death investigation is a team. And we have to exchange and collect information and, recognize that it's all put together to have a optimal result. So I don't have too much to say. Medical examiners play a small part. We're figuring out why the person died. And then if there's something there to collect to give to you guys, well, we're going to provide it.
And then Linda, can you tell us, for the forensic lab piece, you have a big puzzle to put together. Once all that information comes in, some of the uniqueness of working through all of that data.
Sure. So when I was thinking about what to speak about, we communicate in several different ways from a forensic laboratory. We provide training that's not specific to a case. We work with investigators and so forth during a case, and those are really kind of different scenarios. So just as a little history of Virginia to understand kind of the role that we play in Virginia. 51 years ago, our agency we're a state laboratory system, and we were created by legislation, and we were created to provide the scientific services for the state of Virginia. And that was for evidence examination, testimony, and training. So we were not placed within any law enforcement agency or within the Attorney General's office. So we were actually put under the Consolidated Laboratories at the time. We've since been elevated to where we're a standalone agency. But at the time, we were put in the same place as the public health lab, the wastewater testing, the newborn screening, pretty much anything that had anything to do with labs was put together. And they took the local labs and they kind of merged them all in, so that in Virginia, there's a statewide system and there's not local labs really to provide the services. So we have a lot of customers. And because we have a lot of customers and crime scenes all over, evidence that would come in from crime scenes all over the state, we don't go to any crime scenes. So all of the crime scene work and investigative work was kind of delegated to law enforcement. And a couple years after the lab was created, the legislature realized, probably because people realized and brought it to their attention that, really it's very important to have, from the crime scene to the lab and into the court. There has to be some connection between that. It can't be that, that it's completely standalone or things don't work together well. And so they created 2 years later, they mandated us to provide a forensic training academy. And that is training that we provide to law enforcement in crime scene. But it's even more than just crime scene. It includes things like the location, collection, documentation, and preservation of evidence, but also recognition of what our laboratory capabilities are so that they understand the types of evidence that should be collected for the best information that the laboratory can then give. And then this training also includes proper packaging and how to submit evidence to us. And so we have 3 of these training courses every year. And it's a 9-week course, and we try very hard to make sure that there's at least one graduate that is still working as a crime scene person, since people get trained and then all of a sudden they're promoted and then you don't have anybody doing it anymore, for every agency in Virginia. And that common training that's received has proven on many occasions to really be effective in mutual support when there's a large crime scene that might overtax a small agency that wouldn't be able to handle that. A big, one of our most public examples of that was probably the Virginia Tech shooting several years ago, which, was in Blacksburg, Virginia, which is a very small little town. And so you've got crime scene people from jurisdictions around that could just show up and say, how can I help? They've got the same toolkit, they had the same training, and it's like, you over there, and it made it so that something like that was manageable. So one of the things that we expect from those graduates is that they help with other, they're kind of a train the trainer sort of thing when they go back to their agency, that we hope that they are providing information about how best to use our laboratory services with other people in their agency. They also have input, those graduates have input into our DFS evidence handling guide, which is something that's available on our website and has a lot of information about how to properly submit evidence to our lab. But once it's a specific case that we're working on, there are multiple entities that our lab personnel have to interact with. They interact with law enforcement. They interact with people at the Office of the Chief Medical Examiner. We have a medical examiner system in Virginia. And in fact, we have 4 laboratories, and in each of those laboratories, we're co-located with the medical examiners, even though they're under a different state agency because they're under the Department of Health, because they're doctors. But we found that it's very useful to be together so that somebody from toxicology can go and, sit in on weekly meetings of trying to triage cases and that type of thing to have that interaction. And also prosecutors and defense attorneys. But usually the first communication that happens is with law enforcement, and that's, at the submission of evidence. Or for the more complex cases, a pre-submission meeting that happens because we do have some submission policies, because we want to make sure that we are utilizing our resources for the best evidence that will give the answers that are needed in the investigation. You know, you might have a homicide scene that has, you know, hundreds of samples, and, you know, we can't run hundreds of samples on every single case through DNA. So we try and focus those, and we make those determinations of how to start with what items for testing by having a pre-submission meeting. So with those pre-submission meetings, Robert talked about a lot, you know, the potential for biasing information. So that is when, you know, some conversations could be had where there might be biasing information that would be shared. So we try and have the communication at that point with a different person than is going to be doing the examination later down the road. So if it's something that's less complicated, where the evidence is just being submitted, the investigating officers, they're filling out a request for laboratory examination. We're still using paper. Yes, we are. We're still using paper. But so when they're filling out that form, there is a little space for a brief statement of fact where they can give information you know, about the background. There is this much space on that form, about an inch. So we're not looking for, you know, the history of all the people that could be, you know, of interest and that kind of thing, because really all we want to know are the things that are going to help us figure out how to most appropriately do the testing. And again, that's to try and minimize potentially biasing information. So later, the examiner could communicate with the prosecutor. They could also communicate with the defense attorney to answer questions like, you know, what did we do? What were the results that we got? What do those results mean? What are the limitations of any of the results or any of the testing that we did? And you know, for us, I feel like the information that we're giving in those conversations, no matter which party we're speaking about, you know, we're giving the same information. What did we do? What were the results? And so we think that that's important. And it's actually in our code of professional responsibilities and ethics, where we're supposed to fully and honestly communicate with all parties when such communications are permitted by law and our department practice. So one other piece of training that we do to try and increase communication is, since 2019, we've been providing some scientific or technical training to attorneys and judges in Virginia. And the whole point of that is to try and give information about the science and in the particular disciplines for people that are using the testing in their cases, so that they have the background to understand the methods and the practices that are used. So we have been giving this training, and it includes prosecutors, public and private defense attorneys and judges, all in the same room together, which we think is pretty unique. They all seem to think it's unique. But the reason that we, you know, the reason that we do that is that we're not talking about any kind of strategy from the legal side. We're just, you know, trying to provide that information about the background, scientific background of the testing. We also don't offer any CLEs for that training. In Virginia, the bar to get a CLE approved means that you actually have to be talking about the law. And so our training is not about the law, it's about the science. And so it's free, but attorneys are not getting credit for coming. So we're excited that people come anyway. So that's a good thing. And so far we've done these trainings on forensic biology or DNA, on controlled substances testing, and toxicology relating to driving. So it was a couple hours on toxicology testing and a couple hours on the breath alcohol program in Virginia. And we hope to expand this to more disciplines in the future. So I've talked about 3 different types of communication: training for law enforcement, training for attorneys and judges, and then all the interactions that happen with a particular case. And open communication is obviously very important, but it's also important to recognize and protect the neutrality of the laboratory by not making the scientists investigators. Because really what they're doing is, the evidence comes to them, they are doing the scientific testing, and they are providing results back so that the results can be used by the investigators and further on in the process. Thank you.
And then Attorney General Jennings, I know you have some great insight and have shared some pretty great stories about how you've brought some of these concepts together. Can you give us your experience on what it's like working together to bring a case all the way through?
Yes, thank you. And hello, everyone. I wish I could be with you in person. Unfortunately, my schedule does not permit it. And I am assuming you can all hear me. Is that right?
We can.
Great. So I'm really glad to be speaking with all of you today, practicing in your fields and figuring out the best ways we can work together to get at the truth. I have spent the majority of my career as a prosecutor. In Delaware, the Attorney General's office prosecutes all crimes. We do not have district attorneys, so we are statewide prosecutors on everything from misdemeanors to murder. Back in several decades ago, in the late 1980s, I was assigned to a case that I think exemplifies the best outcome we can hope for when we all work well together in our respective fields. And so let me begin. On a Thanksgiving evening, it was raining outside in Newcastle County, Delaware, when a young woman left her home with Thanksgiving dinner. She had been a sex worker, but she was studying to go back to school and become a nurse. She had actually bought her equipment and her uniform on that night. And so she set out, she didn't have transportation, she set out along the Route 40 corridor, hitchhiking into a hospital in the city of Wilmington to deliver a Thanksgiving dinner to a friend of hers who was very ill with AIDS. She never made it to the hospital. Someone picked her up in that fateful evening, and her body was later discovered at an industrial site nearby. She was largely discovered without clothing. She had some clothing on her. She had 3 hammer blows to her head, ligature marks. She had been tortured with various tools and dumped. We didn't know what we had at that point in time. We know that this was a route where there's a lot of interstate trucking and travel that's going on, so we didn't know whether the perpetrator was local. We just knew that she was. And so 6 months went by where we could not, frankly, figure out the identity of her murderer. Prosecutors go to every homicide scene in our state. They have gone to homicide scenes for decades. This was no different. And so it became a mystery. 6 months later, approximately 6 months later in June, the body of Kathy DeMauro was discovered at a construction site. She was discovered completely nude. She had 3 hammer blows to her head, ligature marks, and evidence of torture. Shirley had also been someone who frequented the Route 40 corridor. Before all was said and done, 5 women were abducted, tortured, and murdered. I was assigned to what was then the largest task force in our state's history, 65 law enforcement officers, and 2 of us who were prosecutors. We were looking literally for a needle in a haystack. We did not believe that these women had any obvious connection to a potential perpetrator. But here's what we knew. We knew that there was duct tape found on the victims, so remnants of duct tape where they had their mouths taped shut. And there were bindings that we had on the victims, ligature marks, tool marks, tire track evidence in Kathy DeMaro's case, and blue polyester trilobal fibers that literally coated Kathy DeMaro's naked body. And so we worked very carefully with the FBI behavioral unit, and they told us, you need to put somebody out on Route 40 who is undercover, and she needs to get to know whoever stops for her. So that was what the person who ended up going out on Route 40, Renee Lano, did just about every night with police nearby. And she talked to various potential suspects, but one stood out among all others. It was a man who was operating a van. And when he stopped for her, she noticed that inside his van was carpeting that was the same color blue. And it was a custom-made van where the carpeting was all over the back of the van. And so in talking to this man, she secured some of those fibers. We had a very big evidence suppression motion, as you can imagine, on the lawfulness of that seizure. And those fibers were sent to the FBI that was then doing the forensic testing. And it looked like those fibers were similar to the fibers found on Kathy DeMaro. I won't go into all the details of the surveillance that followed, the circumstantial evidence that we were able to build over time, but it truly was the forensic evidence that made all the difference in identifying the perpetrator and in having the ability to later go to trial and convict him of 3 of those murders. The fibers ended up being the most important part of the case because the police did a painstaking effort to track those fibers down. They were made by the DuPont company. They were manufactured in Georgia, in Dalton, Georgia. And as it turns out, not many of those fibers really made it into carpeting. And the carpeting wasn't inside vehicles. It was house carpeting. And in Delaware, almost none of that carpeting was sold to be put inside residential homes. So the blue polyester trilobal fibers became the critical evidence in the case. Later on, we were able to get a search warrant of this man's van. His name is Stephen Brian Pennell. And we recovered blood inside a wheel well. The van was pretty clean. There was very little evidence to be collected once we got the search warrant, but there was old dry blood in a wheel well. We did not have the capacity to do DNA testing at the time. DNA had been admitted in 4 courtrooms in the country, and that was it, never in a court of law in Delaware. Cellmark Diagnostics did the testing, and the blood came back as being Kathy DeMaro's, so the second victim. And that was the critical breaking point where we were able to make an arrest. The medical examiner who examined all of the bodies, 4 of the 5 victims' bodies were found. The 5th has never been found. But the medical examiner just did a terrific job of linking these cases with each other when you looked at the means and manner of death and torture. They were almost identical, and his evidence was critical to show, yeah, you have enough evidence about Kathy DeMaro. You have the fiber evidence, you have DNA evidence, but how do we know that the 3 cases that went to trial, that those murders were done by the same person? And that's where the medical examiner just played, I think, the critical role in the case. Back then, when I was prosecuting the case, since DNA was just not used in a courtroom very often, and certainly not used in the forensic setting in a criminal courtroom. At the end of the day, the jury they weren't going to buy it. There had been a false positive in some protocol testing that Cellmark did at the time, and that sort of really, really hurt the value of the DNA evidence. Jurors were questioned later by reporters, and to a person, they said the determinative evidence, forensic evidence, were those fibers and showing the rarity of those fibers. If we had not had all of the labs doing outstanding testing, if we had not had the police officers doing outstanding investigative work and prosecutors putting all of this together, this man never would have been identified, and we could never have gone to trial. So I think it's a evidence of when we work together to come out with the best result. And when I say when we work together, but we work independently. It is, as has been said by the other panelists, it's not the forensic scientist's job to convict someone. That's our job. It is the forensic scientist's job to tell the truth with what they're seeing. And it is the forensic scientist's job to ensure that that truth will pass muster in a court of law. And so it all came together. Nowadays, we use DNA evidence to both convict and exonerate on a regular basis. But back then it was cutting edge science, and the jury just didn't buy it because of that false positive. But I was proud to have worked on that case. It was the most incredible example of law enforcement and forensic science and medical examiners working together, just looking for the truth. Having said that, when things go wrong, they can really go wrong. When I was state prosecutor in charge of the criminal division many years ago, we had a division of forensic science. It was run by the chief medical examiner in the state. And at trial one day in a routine drug case, it was discovered during the trial, when the evidence was opened in front of the jury, that the OxyContin pills that the jury thought they were dealing with, and that the prosecutor and defense attorney thought they were dealing with, were blood pressure pills. That was the beginning of the downfall of the medical examiner's office. We learned later that hundreds and hundreds of cases have been compromised. Drug evidence was replaced by powder or other pills in many, many instances. The entire lab was padlocked by the Delaware State Police at our urging. And in the months and months that ensued, we lost over, I believe, 700 cases because they could not stand up in court. There were over 1,000 motions to dismiss filed by the public defender's office, rightfully so. The chief medical examiner was prosecuted for official misconduct because, frankly, he was missing in action. He was using state resources to further his private consulting business. Others were prosecuted as well. But it was an instance of when things go wrong, they can really go wrong. So I just want to say it because thank goodness that the people in your room, the panelists, and forensic scientists throughout the country really adhere to the highest principles to make sure that the evidence that we are presenting is, in fact, the truth. Thank you for hearing from me. I'm happy to take questions. I do need to jump off a little bit after noon because I'm supposed to be in court.
Do we have questions in the audience first for Attorney General Jennings? No one, right? No.
Well, I can ask a question for both. Is for both the special agent and Attorney General Jennings. You all may recall the Washington area sniper case years ago, in which people were killed in several counties in Maryland, several counties in Virginia. It could have been prosecuted in each one of those counties and in federal court. So you had lots of police departments with their own egos who wanted to handle that. A lot of prosecutors with their own ego. You had the Attorney General and others. How would the two of you choose which jurisdiction that should go in? What considerations would you have?
So I'll let Attorney General Jennings go first, and she's got to leave.
It's a great question, and no one is immune from these territorial fights. They're unfortunate, but the answer is the jurisdiction that can most efficiently and effectively handle the prosecution should handle the prosecution. You know, it's so easy for us to point fingers and to fight over territory, and it happens in Delaware. It happens sometimes in the field of gun arrests with violent offenders who pick up a gun. And sometimes the federal government will take the case, and sometimes, most of the time, we will take the case. So it's important for us to realize that, look, ultimately, we want the best possible result. Does it really matter if it goes to federal court or it stays in state court? You know, it's something where the better part of ourselves has to prevail. I will say, too, that in this task force, the 65 law enforcement officials who comprise the task force, you know, several were from the Newcastle County Police, several were from the Delaware State Police, and then there was us. And there was an argument for months over whether we had enough evidence to arrest Stephen Brian Pennell, and we held off till we got the DNA evidence. I think it was the right decision. Things weren't always pleasant, but I think we worked toward the greater good, and ultimately we succeeded because we put our own sort of sometimes petty feelings aside.
What I'd also like to add to that is, in working a lot of the crimes against children cases that I have, there's often very duplicative charges, both at the federal and the state level. I have come from the Washington field office, basically in Virginia and DC is where we worked everything. So what we would do is if we had cases in Virginia that we thought could go either way, could go a federal charge or a local charge, depending. We oftentimes would bring our local prosecutors in to talk with the AUSAs, and we would all sit down and look at who has the better case based on the charges that are available, because a lot of the states have enhancements or additional charges that could be brought that can't be done at the federal level. And if we've got a really strong case, just because we might want it, we may only get, say, 5 years because it's a mandatory minimum case, but we know if we took it at the state level, that offender might get 15 just based on enhancements or other things. Kind of going to the general's point is putting the ego aside of saying, hey, I really want that case because, you know, I could take it federally, but it's going to be better served being prosecuted at the local level. So we oftentimes would get together as a group and work together to decide who actually had the better venue to prosecute that individual.
Hi, so piggybacking off of that last question, how would you handle a situation where someone would refuse to put aside their ego, or someone who wouldn't want to play game, whether it be between a sheriff's department and a police department, or between a prosecutor and a medical examiner, or whatever have you? Because we definitely have situations where that happens.
I can speak to, from our experience, we still have that happen almost regularly on cases. It's very difficult. Sometimes those decisions get made at a much higher level than just, say, like the traditional investigators or even their supervisors. It kind of has to start going up to the higher levels to decide who actually has it. And sometimes they get in fights over it. Sometimes they never agree. And that's why a lot of times you wind up with federal charges and state charges for the same person. And sometimes often for somewhat similar type crimes, because sometimes they can't agree. So they'll just go ahead and say, well, you file that and then we're going to file this. But most of the time there is usually some type of resolution. And it just boils down to a conversation that even if it has to go up to, you know, the police chief and, you know, one of the head of the FBI office, because sometimes it does come to that. They usually do come up with some resolution.
Yeah, and I think that's absolutely right. It does have to go higher up. But one of the keys here, and it's perhaps easier in Delaware, we're a small state. The governor calls us a state of neighbors. It's very true. But neighbors can have disputes too. And so building those relationships in advance so that even if we disagree, we are deferring to the agency that has, I think, the better ability to bring a case. And it's just, I mean, we're in this to help victims, right? We're in this to bring justice to victims. I once remember when a rape case, actually, it was he was a serial rapist, awful human. He raped several women, carried one across state lines. She had to dive out of his moving vehicle just to save her life. And the U.S. attorney ended up taking one case and the state ended up taking the other case. That made no sense to me because those cases could have been tried together with the commonalities. So that's an instance when the best thing didn't happen. And I think that's a real disservice to the cause of justice.
Good afternoon. And I don't want to hold the AG up, but she's got to dart out for court. As you're independently working cases that come to your attention, and the fact that we've got a 24-hour news cycle going on, so the media tries to jump on something and link cases before there's actually a link. When you start to notice cases that you're independently working and know, oh God, we've got something that appears to be repetitive, how do you communicate that up, down, or sideways to try to get everybody on board to review those cases and establish that link before it becomes the bad word that we like to say in most jurisdictions is serial? But before it becomes that, how do we attack that before it becomes an issue?
It is terrifying when you learn that, for example, you have a serial killer in your midst, and the pressure on law enforcement and everyone else involved to identify and make an arrest is enormous. It is enormous. And so I just think early on, we have to have our ducks in a row. We need to be prepared as we possibly can. And we need to communicate with our counterparts to make sure that everyone is telling us the information we need to make decisions. You know, you are right. We're in a, I think, less than 24-hour news cycle. It's with the presence of body-worn cameras, I think, a great thing, but it does present its challenges for law enforcement and for prosecutors because people expect to see what happened and they expect to see it tomorrow. So I just think it's important. First of all, we need to have strong policies in place that apply to every case. So we have a body-worn camera policy in Delaware. Every police officer in the state has a body-worn camera. But it just is, that news cycle and that pressure can be enormous, and it's hard to deal with. Well, thank you very much. I wish I could see you in person, and hopefully someday I will. Take care.
Thank you. And then, so I would also like to add to that. So in our state, our law enforcement's a lot of times worked in silos until my position started. And so now overseeing the cases that come in on a daily basis, I can see across the entire state. And so we can see when things are happening that aren't unique. And so, for example, last December, we had 8 overdoses within about 48 hours across the state of Montana, which they happened in 8 different counties, right? So one overdose in each county didn't particularly get anyone's attention. When I read cases that Monday morning, there were 8 overdoses in our state that resulted in fatalities in 48 hours. So I called, we have a narcotics agent in our state. I called him. He hadn't noticed it yet because they hadn't caught the living overdoses from the weekend. They hadn't caught up with it yet. And we noticed the spike and were able to put out an alert that we had a batch of drugs come through that was particularly more fatal than in the rest. So it depends where you're at. If you can get people out of the silos and you can have communication interagency, you start seeing those patterns faster and you can pick up on them, either countering the news or finding what substantiates that.
And just to add on what Kayla has mentioned there, if you look at death investigation systems as a means of detecting some of those issues, there are systems which are centralized, state medical examiner systems. Utah is a good example, or Albuquerque, in New Mexico, Maryland. In Montana, it's a really small community with really long streets, about 900 miles from diagonal to diagonal, with 56 coroners. And so it was integral for us to coordinate the state medical examiner's office with all 56 counties, and a means of, in real time collecting information about deaths that occurred and having resources like Kayla, our state crime lab, and piecing all that together. It really made our, I'll say, immune system more effective in a broader area.
Other questions? I thought I saw 1 or 2 more. So I think the other thing we haven't addressed is the change in information as it progresses through some of our different pieces. So as you go from the field to the medical examiner into the lab, when you go from the field, there's an initial creation of what may have occurred. When you get to the medical examiner, that story could change drastically based on what you're seeing. How do you communicate those changes from the field as it goes through the process, or do you communicate them? And if you do, who are you talking to overcome that change in information, and why is it important?
Please go ahead.
So for me as a medical examiner, I'm collecting information from the coroners who are reporting death, but we're also working with local law enforcement. And when they bring in the information, we just take that at face value. I really can't assume that it's accurate or inaccurate. And I have to, or the staff would have to, perform a postmortem examination. And of course, we're looking at the cause and manner of death. But one of the key aspects of forensic pathology is taking a look at pattern and distribution of injury and how it relates to how that injury was sustained. Is it an entrance? Is it an exit? Was it front to back, back to left, or excuse me, right to left, or otherwise? We can piece that information together, but we're also collecting evidence from the body that would be turned over to law enforcement. And so we have to work with them as effectively as possible and utilize whatever means are necessary to try to detect that information. So if you're using an alternate light source to see evidence that you might not otherwise see that might be invisible, if you don't collect it, it doesn't get tested. It's piecing all that information together and then conveying that information to the appropriate entities.
And I would just like to add that from an investigative perspective, so all of our cases, we work with the medical examiners. When we get their reports, we would review those. When we get the reports from the lab, we would review those. And then as the special agent in charge of that investigation, you then look at all of that information. And that's when we would start talking to our prosecutors and saying, hey, based on the reports that I've read and the conversations that I've had with our forensics lab or our medical examiner, these are the things that we're seeing. How do we want to proceed? What charges do we have available? And that's when we kind of start thinking about the prosecution aspect of it. So from my perspective, I'm kind of always looking and having conversations with all of the components that go into the investigation. Because if any of that information changes from what we initially thought, then that's usually immediate phone calls to whoever it is that needs to be involved in that.
Right. And I would say from the laboratory perspective, like the medical examiner, we kind of take on, on face value, the evidence that is submitted, and send back our certificate of analysis with the results. And, a lot of times we will then get a call from the investigator saying, this is not exactly what I expected. Can you please, can just explain to me what this means? And, that's a very important part, because it is true that sometimes forensic science reports are not all that easy to read. I own that. But we, we have to have a lot of information on those reports that talk, that outline everything we did and the methods we used and all of that kind of stuff. And so sometimes, the actual conclusion, although certainly reported, might be somewhere down in the middle, and and it's great to be able to have that conversation to make sure that everybody understands what the meaning is. And based on the in answer to a question earlier, if we see something where it might link cases together, we're obviously not part of any kind of media. We're not going to talk to any media about any cases that we're working on. That information belongs to the investigating agencies. But if there are links, we may actually, that were not necessarily expected, we may not just send that report, but have the examiner go ahead and reach out to the investigator saying, hey, I'm putting this in the mail. It has this information in it, and I just wanted to flag that for you so that you would notice it as soon as possible, so that you could follow up, and then I'm happy to answer any questions once you get it and have had a chance to review.
They're coming.
Nobody else?
There's one more in the back as well, but
No, they can.
okay. Go ahead.
I guess I had a question about the lab interface. In my jurisdiction, we have a team that goes out from the lab. We have crime scene services, which are state troopers that process for latent and friction-rich evidence. And, the interplay of that is crucial at the scene, because so many times a trained scientist will see something in a different way, and particularly using bloodstain pattern analysis. And what I find as a prosecutor is they are looking for scientific underpinnings of the information. And I don't know how training people in all kinds of, the number of counties and jurisdictions that you have allows for that type of expertise. Like someone in a small town that doesn't see bloodstain pattern analysis, I don't know how they can, contribute. So I would wonder that if you're not losing some investigative capability by not having, the eye of someone like the speaker yesterday from Idaho that came out and was able to identify. I can think of a number of crime scenes where things were completely overlooked by a number of people until, the crime scene response from the lab identified that. And, just being able to, right from the get-go, not waiting months for the reports to come out to find out that your investigative theory at the scene is incorrect, because it could have been spotted by more of a trained eye.
I appreciate the question. I think that, that is why it's so important to make sure that the training that is provided to those crime scene specialists within law enforcement is robust. Truthfully, when you have someone who would go out to the scene from the lab, at least in our laboratory system, they don't have the expertise of all the different disciplines. Everyone is focused on their one discipline that they do, whether it's firearms or latent prints, or drugs or whatever. And so, we try and have the folks that are trained for crime scene to have information about all those different types of things. And we're also pretty clear that if you have questions about anything that you're seeing, we're happy to answer, we're happy to answer those questions, or they are a community amongst themselves, and we'll reach out to other examiner or other crime scene people from jurisdictions that are close by if someone has a particular expertise in blood spatter or something like that. So, I mean, I'm sure there are pros and cons to both of those ways of providing that service. But, and it's something to be aware of, but that is why we try and, provide the more robust training.
And if I may add, for the federal system, most of the time, our laboratory also does not go out to any crime scenes. They're all centralized at Quantico. The teams that I manage, every field office has an evidence response team. Every single one of them gets trained exactly the same way. They all get trained on basic evidence collection, and then they can choose to go to, how do I want to call them, advanced trainings for more specialized techniques and things like that. So, it's also the same for us that if we come across something that they can't collect or they don't understand how to collect, they absolutely can reach back to the specialty in the lab and say, hey, this is what I'm seeing. Is there something special about this that I need to know? So we kind of have a similar system where we're sort of broadly trained to collect everything. And then the lab is actually doing the analysis that's going to provide that expertise. So is there a chance we would miss potentially something at a crime scene? Possibly. But I know, like, I'm sure the Virginia lab, or I'm sorry, the Virginia crime scene folks do as well. We do the best that we can to collect everything that we think would be relevant and document it as well. The FBI is, at least our evidence teams are huge about taking photographs of everything. So that's one of our big things, is almost over photographing, if you will, just in the event that somebody else would see something and have maybe a different look.
And I'll just add to that one other piece to this. As specialists in various fields and forensics, there are certain things that we'll look at which might initially have a subjective interpretation, but that subjective interpretation is based on finite objective characteristics, and we all have to work as educators and working together as a team. And if you're able to elicit the objective characteristics that a person can recognize, you're communicating great information that they can utilize to move forward, to add to their own experience. But it lends to raising the level of detection within the community. I mean, one of the things that I like to use as an example is that where the state medical examiner's office in Montana had to work with 56 different coroners. And, how do you work with the coroners to have them recognize, when cases they need to come in, or maybe cases that don't need to come in, or cases perhaps that they are able to successfully document on their own.
Is there somebody else? So let me ask the question about this. We've talked about how you choose jurisdictions and prosecutors, but my question is, how do you choose the lab? So as a hypothetical, there's a crime that occurs in Virginia, but could have federal jurisdiction and state jurisdiction, but the decision has been made yet as to who's going to take the lead and who's going to prosecute. How do you decide whether you send it to Linda's lab, which is one of the best in the country, or to the FBI lab, which is maybe second to Linda?
Wow.
I'll just start off, at least from the federal perspective, if we're involved in the case, then if the decision, usually if the federal, for us, all the stuff I've been involved in, typically if the federal cases if we're involved, it's going to our lab. Unless there is something for some reason that we don't do at our lab, then we would send it out to a different lab. If the case starts out in Linda's lab and then at some point in there, they decide that they don't have the right charges or federal charges would be better, our lab would just use that evidence. They won't, the FBI laboratory doesn't, I'm trying to use the right words here. We don't re-examine evidence for something that was already looked at, but they can do a new exam for something different, if that makes sense. And you probably have more of the right terminology, Linda.
I was like, and we're the same way, that
Mhm.
if something had originally been done by the FBI lab, we would not re-examine using the same type of examination. If there was some other examination that had not been done yet, we could do that. And that is that is pretty much standard across all forensic laboratories across the country of not re-examining, what another laboratory has already done. And there's multiple reasons for that. One reason in particular is that sometimes the evidence is very limited and you always are trying to keep a little left that has not been tested. And so that can be difficult if it's going to be tested multiple times. But similarly, usually if a local or state law enforcement person is doing the investigation, those would then be submitted to our laboratory. Our statutory authority allows us to do cases for federal cases if we have the resources to do that. So right now, like if you asked me to do a DNA case, I would say we do not have the resources to do that because we are so behind just with our state cases. But the thing that most often comes up are drug cases when it's will it go federal or will it go state? And that's because there are also a lot of task forces that contain both state and local as well as federal partners on that task force. And a lot of times, so we'll ask the question, do you know this is going federal from the get-go? And if they know it's going federal, it's actually better if it goes ahead and goes to the federal lab, because there are some different things that are required for the analysis based on the statutes in the federal code that are not necessarily in the Drug Control Act in Virginia. So for instance, we don't determine if some methamphetamine is ice or not, because there's no such thing as ice in the state of Virginia. And so they might do additional testing at the DEA lab to make that determination, because it is something that has a penalty differential in the federal system. But if it's unclear if it's going to be taken federal, which is a lot of the time, we'll go ahead and do that. And so we'll do our analysis, and we're going to use our procedures that would be applicable for the state drug laws. And if it ends up going federal, we may need to do something like a base determination for cocaine or something like that. But usually that's kind of how it is handled, and it's usually more drug and sometimes firearms than the other types of examinations.
Right. So the second part of that is, as you remember, a former attorney general, as a result of the National Commission on Forensic Science, told federal prosecutors to avoid having state laboratory experts testify if they are not accredited. So when you come up on a situation like that, where the evidence has been given to a non-accredited lab, and the fact that you don't reanalyze evidence, as you had just indicated, how would you handle that situation?
I can't answer that because I don't work at our laboratory in that capacity to do those analysis exams. I don't know if you would have
I wouldn't want to speak for them either.
Yeah.
To know how they would handle that. I will say that more and more laboratories are accredited at the state and local level. Certainly we've been accredited, and I think all state laboratories are accredited.
Just a real about training. One of the things I thought that when I was working in Oregon State Police, we were in a metropolitan laboratory. And one of the things we instituted was having a newer deputy DAs that are getting into major crimes. Usually they're Deweys, and then they may work their way up. We had kind of like a new deputy DA interns. They had to go through our laboratory and also the medical examiner's office and all that. And they spent like 2 or 3 days in our laboratory to actually see all these processes. Some might see more than others, but they at least had, most importantly, the contacts that they knew if they had a question and they were their first sexual assault case, their first drug case, their first whatever major crime, they had a connection. And they also knew a lot better about the capabilities and limitations of the laboratory. Now, I know a lot of laboratories are local and all that can't do that, but maybe you might want to think about having what we call an internship, a short 1-week internship for the prosecutors in the area, at least for the major crimes.
Yeah, I mean, it seems like a really good idea. We obviously have jurisdictions across the state, and that would be a lot of new folks, because there does seem to be some turnover in the Commonwealth's attorney's offices.
All of them areas.
Right. I will say that the organization, the professional organizations in Virginia have been very good about making sure that we, as the forensic science department, are on the agenda of their, like for Commonwealth's attorneys, there's a meeting where they provide training to all of their Commonwealth's attorneys in the spring and in the summer. And then there's an executive for the electeds in the winter. And so we provide an update at each of those. I just actually did the one last weekend for the summer, and I can talk about the fact that we're going to have new wording on our latent print reports to give them a heads up about this is what the new wording is going to look like, and this is what it means, so that we can present that kind of stuff. And also for Virginia Chiefs of Police and the Sheriff's Association, we try and get on their agendas to make sure that we're providing updated information as well.
All right. So it looks like there's any additional questions.